So, in terms of self-defense generally and who bears the burden, um, in relation to self-defense, defense of another, and defense of property, the common law defense of self-defense, and indeed Section 76 of the Criminal Justice and Immigration Act 2008, does what the Court of Appeal have referred to as clarifies the common law and puts it on a semi-statutory footing. And I say semi-statutory in the sense that it doesn't replace the common law. So we have both really working in tandem. So it's not purely on a statutory footing. It's not purely on a common law footing either. So we are somewhere in between, really. So we are riding two horses in the same self-defense race, effectively, but they're both going in the same direction, largely speaking.
I think the court were effectively saying, weren't they? And it's a general point that, of course, once you start attacking the character of someone else involved in the proceedings, then the whole of your character becomes an issue, and the jury can learn about all of your previous convictions.
Yeah,
it's not limited. It's not limited to convictions of violence.
No.
So it's a very dangerous game to start attacking the character of someone else involved in the proceedings, because you might find yourself on the receiving end of an application by the Crown that the jury or the magistrates get to hear about everything that you've got in your past, as it were, to redress the balance. Well, if you're attacking their character, what's your character like?
Self-defense. Turning to self-defense then, the prevention of crime under Section 3 of the Criminal Law Act 1967. Of course, as we all know, a person may use such force as is reasonable in circumstances in the prevention of crime, including arrest. So it may well be that you are assisting a police officer. It might be that a police officer is outnumbered or they're outgunned by a particular person they're trying to remonstrate with. It might be that a small probationary constable is trying to arrest some 6'6" character and he's struggling, and you may go and assist them in the circumstances. In the case of Hitchens back in 2011, of course, you can extend to force against an innocent third party. The case of Hitchens was interesting in the sense that the defendant was alleged to have slapped the complainant's face, and she was urged not to open the door to the flat because had she done so, her ex-partner could have entered, and that was held to be reasonable in the circumstances in terms of preventing a further assault upon that person.